Know your right at workplace. Key point of sexual harassment at workplace. Act or behavior of sexual harassment. Workplace. Which workplaces come under the POSH Act 2013? Who are the aggrieved women? Why was the government forced to make this act? Vishaka guidelines. Key point of sexual harassment at workplace. An important part of sexual harassment that it's one-sided and unwelcome. Sexual harassment and romance and friendship differ greatly, as these are two people's mutual feelings. Often sexual harassment makes the aggrieved woman feel guilty, but it's important for the aggrieved woman to remember that it's not her fault. The blame lies squarely with the person who is the harasser. Sexual harassment affects all women in one way or another. Distinctions made between sexual harassment and gender-based harassment. It emphasizes the fact that sexual harassment doesn't always mean sexual desires. It can also be a man's claim to power over a woman. Such behaviors and actions weigh heavily on women's emotional health, hindering her personal and professional development. According to various studies, in a workplace of small numbers of women, a large number of women have suffered sexual harassment and a large number of complaints have not even been filed. Culture of silence fostered in girls' education has led them to quietly become victims of patriarchal attack, which is why many cases go unreported. Act or behavior of sexual harassment. The Sexual Harassment of Women Prevention, Prohibition and Redressal Act 2013 states that if the following circumstances occur or are present in relation to or connected with any act or behavior of sexual harassment, it may amount to sexual harassment at the workplace. Implied or explicit promise of preferential treatment in her employment or implied or explicit threat of detrimental treatment in her employment or implied or explicit threat about her present or future employment status or interference with her work or creating an intimidating or offensive or hostile work environment for her or humiliating treatment likely to affect her health or safety. Workplaces come under the POSH Act 2013 are workplaces is defined as any place visited by the employee arising out of or during the course of employment, including transportations provided by the employer for undertaking such a journey. As per this definition, a workplace covers both the organized and unorganized sectors. It also includes all workplaces whether owned by Indian or foreign company having a place of work in India. As per the Act, workplace includes government organizations, including government company, corporations and cooperative societies, private sector organizations, venture societies, trust, NGO or service providers, etc., providing services which are commercial, vocational, educational, sports, professionals, entertainment, industrial, health-related or financial activities, including production, supply, sale, distribution, or service. The workplaces are hospital, nursing homes, sports institutes, facilities, places visited by employee, including while on travel, including transportation provided by employer, a dwelling place or house. The Act defines the unorganized sectors as any enterprise owned by an individual or self-employed, workers engaged in the production or sale of goods or providing services of any kind, any enterprise which employs less than 10 workers, all women working or visiting workplaces. Who are the aggrieved women? The Act recognizes the right of every woman to a safe and secure workplace environment, irrespective of her age or employment work status. Hence, the right of all women working or visiting any workplace, whether in the capacity of regular, temporary, ad hoc, or daily wages basis, is protected under the Act. It includes all women, whether engaged directly or through an agent, including a contractor, with or without the knowledge of the principal employer. They may be working for remuneration or voluntary basis or otherwise. Their terms of employment can be express or implied. Further, she could be a co-worker, a contract worker, probationer, trainee, apprentice, or called by any other such name. The Act also covers a woman who is working in a dwelling place or house. Aggrieved women. Who are these? Working, visiting a workplace, student. And the working women are domestic worker, regular, temporary, ad hoc, daily wager, for remuneration, voluntary basis otherwise, employed directly through an agent, contractor, worker, probationer, trainee, apprentice, called by any other such name. Visiting a workplace means it is as if a woman has gone to some place from outside for some work, even if she does not work there, but if she is sexually harassed by any employee there, then it comes under this definition. Why was the government forced to make this act? Bhavani Devi gang rape case in 1992 could be called turning point where calls for legislation on workplace harassment started. Bhavani Devi was working as a social worker under the Rajasthan government in the Women and Child Development Department. She engaged in preventing child marriage when she was gang raped by prominent and affluent community people. Subsequently, the incident received widespread coverage by the media when the accused were acquitted by a lower court. In response to this episode in 1997, some non-governmental organizations filed a writ petition in the Honorable Supreme Court to protect women's fundamental rights under the Article 14, 19 and 21. Article 14 Right to Equality, Article 19 Right to Freedom, and Article 21 Right to Life and Liberty. This petition specifically addressed the issue of sexual harassment of women in the workplace. Supreme Court issues Vishakha guidelines to become law on subject given absence of domestic law on the matter. Vishakha case, named after a non-governmental organization called Vishakha, NGO works for women's rights in Rajasthan. The objective of the Act is to promote gender equality and ensure a safe and dignified work environment for all employees in India. The essence of the action is taken from the Vishakha guidelines with the comprehensive framework to deal with sexual harassment cases. Act its laid down procedure for filing complaint and inquiring and action to be taken. Vishakha guidelines. The court for the first time relied on an international human rights law instrument, the Convention on the Elimination of All Forms of Discrimination Against Women, to establish guidelines known as the Vishakha guidelines. These guidelines address the workplace hazards faced by women. The court emphasized that the employer must ensure the safety of their employees and others affected by their business. The court stated that such incidents violate the fundamental rights of gender equality and the right to life and liberty as guaranteed under the Article 14, 15 and 21 of the Constitution. Consequently, the court issued a writ of mandamus and provided specific directions for prevention, such as it shall be the duty of employer or other responsible person in workplaces or other institutions to prevent sexual harassment and to provide for the resolution and settlement mechanism. The code defined what constitutes sexual harassment. For this purpose, the sexual harassment includes such unwelcome sexually determined behavior, whether directly or implication, as physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal, and non-verbal conduct of sexual nature. Although the Vishaka guidelines only apply to traditional office settings, the POSH Act introduces the concept of extended workplace, recognizing that harassment may not necessarily occur in the workplace itself. In accordance with the Section 2O of the Act, a workplace refers to any place visited by an employee as a part of his or her employment, including any transportation provided by the employer for traveling to and from work. In Saurabh Kumar Malik versus Comptroller and Auditor General of India 2008, the respondent, who had been facing departmental inquiries for allegedly harassing a senior woman officer, conducted that he could not be accused of sexual harassment at work since the misconduct reportedly occurred not at work but in an official mess in which she resided. A further argument made was that the complainant was in a senior position to the respondent, so he could not extract any favor from her, and therefore the act did not constitute sexual harassment. This was deemed as clearly misconceived by the Delhi High Court. In its consideration of the case, according to Delhi High Court, the official mess where the employee reported being sexually harassed fell under the definition of workplace under the POSH Act. In my next video, I will tell you whether harassed woman should lodge a complaint and what are the rules for filing a complaint. Thank you. Jai Hind.